Hello, in this video, we're going to discuss some of the topics that you're likely to see covered in your first year real property class. Now, I want to start by saying that real property is often considered one of the most difficult classes in your first year of law school. And some of the reasons for this are that it's a dense subject. These are some tough concepts that we're about to go over. Another reason is that this law is fairly antiquated. We're going to learn some things in real property that are fairly older laws that you might think aren't necessarily relevant anymore, but are still covered in real property. They also use a lot of terms that may not be super familiar to you because we simply don't use them in everyday language. And so learning some of these terms can be hard as well. In my time tutoring for real property, I've come across many students in many different schools, and I've seen that teachers teach real property vastly differently from school to school. So I'm going to go over an overview of many concepts and topics that are frequently incorporated into a real property class. But just be aware that you may not cover all of these topics in your particular real property class. Sometimes professors like to focus on one particular area of real property, or they spend more time covering a topic than others, and some professors may skip that topic altogether. I'll point some of these things out as we go through this information. So I want to start by talking about some fundamentals of property and some basic topics that I think will help you understand some of these more specific and detailed topics that we're going to talk about in just a little bit. The first topic, or first fundamental that we have, is attributes of property. Now, your professor may teach you this analogy. This is a very common analogy in real property that they refer to as the bundle of sticks. When you own a piece of property, there are a lot of attributes that come along with ownership. So for instance, as the owner of a piece of property, you have the right to exclude other people from that property. You also have the right to dispose of that property. You could sell that piece of property. You have the right to use or possess that piece of property. Collectively, we think of each one of these attributes as a stick. And so when you own a piece of property, you have all of the sticks in the bundle. Some professors use this analogy, some don't, but even if they don't, it's a really helpful way to think about ownership of property and the different attributes that come along with it. Even though this class is titled Real Property, usually, some professors will include a discussion of personal property as well. So I want to distinguish between those two things. Real property is things like land, the buildings on them, the area below the surface. So think of like physical property, like land. That's what we're talking about when we say real property. The converse of real property is personal property. Personal property is something like an item that is movable. So if you have furniture, that's your personal property. You may go into a discussion of what is property in your class, and a lot of times some things that may or may not seem like property right away are analyzed, and you'll talk about whether to include those in things like personal property. For instance, you may talk about things like wild animals. Are wild animals property? And if so, who owns them? Some teachers include some sort of intellectual property discussion. Is a patent property? Some teachers talk about cases that involve things such as stem cells. Are stem cells property? Do you own your own stem cells? And if so, can you sell them? And things like that are kind of gray areas of the law, and they make for really interesting discussions. The next topic or fundamental to talk about is the difference between a freehold and a non-freehold estate. This is one of those words that we don't really use in everyday language. We don't refer to our house as our freehold estate. So this is some piece of vocab to pick up on that may help you understand the topics that we're going to talk about in a little bit better. When we're talking about a freehold estate, we're talking about an estate that a person owns. So a freehold estate would be like the house that you buy. Compare this to a non-freehold estate, which is like a lease. When you're leasing an apartment, let's say, you don't own that apartment. So we don't call this a freehold estate. You don't own it free and clear. The landlord owns it. So instead, we call that a non-freehold estate. You have an interest in the apartment. You get to possess it. You get to use it. You get to invite or exclude other people onto it, but you don't have that ownership interest. So that would be a non-freehold estate. Finally, the last fundamental that we have is the idea of caveat emptor. This is a Latin phrase that means buyer beware. This is a concept that you'll probably see underlying a lot of the different types of cases and topics that you talk about in property law. This idea that some responsibility is placed on the buyer when they're purchasing a piece of property, and they don't always have a recourse against the seller if something goes wrong after the sale takes place. Okay, moving into some personal property topics that you may cover. Now, like I said, this is one of those things that some teachers may include in their real property class, some may not. Just in case this is something that your class goes over, I'm going to give a brief introduction and overview of the types of things that you'll discuss as personal property. The first one is findings. And here, there's a distinction to be aware of between abandoned property, mislaid property, and lost property. And the reason is, if property is classified as abandoned versus lost or mislaid, it changes who the true owner of that property is. So let's say, for instance, that I have an old chair that I decide I don't really want anymore. So on trash day, I put that chair out by the curb. Well, one of my neighbors, while walking their dog, sees the chair, thinks, that's a nice chair. It would look good in my living room. So they take it from the sitting next to the curb. They take it and they put it in their living room. And then I go to their house a few weeks later and I see my chair. And I say, hey, how did you get my chair? That's mine. Why is it at your house? Well, they have the best argument here. They can say that I abandoned that chair, and as such, I gave up my ownership interest in that chair. So the person who abandons property no longer has a good claim to that property. Instead, the finder has the best claim to that property. Now, contrast that with lost or mislaid property. Let's say, for instance, that I'm at the store buying some groceries, and as I'm looking through my bag trying to find my credit card so I can pay, I pull out my car keys and I set them on the counter just to get them out of the way. And then I find my credit card, I pay for my groceries, and I leave the store without my car keys. I mislaid my car keys. So if the customer who was in line behind me walked up to the counter, saw my car keys and picked them up, they didn't get my car. They also don't get my car keys. That would be mislaid property. So mislaid property remains the property of that true owner, the person who mislaid it. So that finder does not have a good claim to the property in that instance. The same thing is true of lost property. If I'm walking my dog and let's say my keys fall out of my pocket and someone else happens to come across them, they see them, they pick them up, I did not give up title or ownership of my keys or my car. And so that finder does not have a good claim to the car or the keys. I still own that property, so I have the best claim to that property. Now, the finder of lost property has a better claim to that property than anyone else other than the true owner. So if one of my neighbors finds my car keys and then someone sees that, let's say neighbor number 2 sees those keys in neighbor number 1's possession, and neighbor number 2 says, those aren't your keys. I'm going to take that. I'm going to take those keys from you. Neighbor number 2 will not win there. Between those two, the first person, the finder, has the better claim, but between me, the true owner of those keys, and that first finder, I still have the best claim. The other topic we have here is gifts. And there are 2 types of gifts that often come up in a law school class, inter vivos gifts and gifts causa mortis. An inter vivos gift is a gift given during life, inter vivos meaning during life. And the elements of an inter vivos gift are intent, so the gift giver intends to give a gift, delivery, and acceptance, whether or not the donee, the gift recipient, has accepted the gift. And where these cases that you might read turn on is that element of delivery, because they recognize that delivery doesn't have to be actual physical delivery in all instances. It could be enough to have constructive delivery. So for instance, if my grandma wants to give me a car for my birthday, it's going to be pretty difficult for my grandma to pick up and hand me a car to carry out delivery. Instead, what my grandma might do is hand me the keys to the car. So she didn't physically deliver the car itself, but by delivering the keys to me, she has constructively delivered the entire car. The thing to note about an inter vivos gift is that once those three elements are met, intent, delivery, and acceptance, then the gift becomes irrevocable. So once my grandma gives me those car keys and I accept it, she can't take it back. She can't change her mind. She can't give that car to someone else. It is an irrevocable gift. Now for a gift causa mortis is a gift made in contemplation of death. We have some similar elements here. We're still looking for intent to make a gift. We're still looking for delivery. We still generally need acceptance. The difference is that this type of gift is made in contemplation of death. Now, this is different from a gift left in a will. We're not talking about gifts given in a will here. Let's say, for instance, my grandma is on her deathbed and she has decided that she wants me to have her car after she dies. So she thinks she's dying, she's ill, she calls me in and she says, Heather, I want you to have my car upon my death. Here are the keys. So we have the intent to make a gift. I have the keys. I have constructive delivery, and I'm going to accept that car. But the difference here is that that gift is not complete until she actually dies. So let's say my grandma makes a miraculous recovery and now she needs her car. She has to be able to get around still. She could come to me and say, you know what? I didn't die, so I'm going to revoke my gift. And that would be okay. A gift causa mortis is revocable until the person actually dies. So even though it's been delivered, the gift isn't complete until the death. All right, let's move into some real property topics now. The first real property topic we're going to talk in more detail about is freehold estates. I mentioned at the very beginning when we talked about those fundamentals that a freehold estate is an ownership interest in property. So here we're going to classify what type of ownership interest a person may have in property. This is one of the topics that most law school professors cover, but I've seen wide varieties of how in-depth the professor goes when discussing this topic. Some briefly gloss over it, and some cover this in extreme depth. So I'm going to give just a general overview of what these different freehold estates are and what some of these vocab terms mean. So the first freehold estate is a fee simple absolute. Now, this is probably the one that you are most familiar with in reality. A fee simple absolute means that the person who owns the property outright, not subject to any condition. They own it forever. They can sell it. They can leave it to their children. They can do whatever they want with that property. So they get the entire durational interest of the piece of property. And when looking for granting language, we give a fee simple absolute with language such as to A or to A and her heirs. So a grant that has that language in it would be creating a fee simple absolute. Now the next option is a fee tail. So this one in the grant, it would look something like to A and the heirs of his body. This is one of those antiquated terms. We don't really use this all that much anymore, but it's still usually mentioned in law school classes. So when you have a fee tail, the difference between a fee tail and a fee simple absolute, remember, you get the property forever, no conditions. In a fee tail, the property owner, so here that's A, gets to keep the estate as long as A and their descendants are holding it and survive. Meaning that if the last living descendant of that line dies off, then that line doesn't get to keep the estate anymore. It's going to revert back to the grantor. The third and fourth freehold estates, I think of hand in hand. They are fee simple determinable and fee simple subject to condition subsequent. With either one of these freehold estates, the person who owns the property owns it typically subject to some sort of condition. So they own it, they're the owner of property. So this isn't an instance where they're just leasing it or in possession of it. They're truly an owner. They have an interest in the property. But if the condition takes place, their ownership interest in this property is going to be or could be taken away from them. So for a fee simple determinable, this one is applicable where the condition attached to the ownership of the property is some sort of time or duration. And so for that time or for that duration, that person owns the property. But then once the time expires, the property reverts back to the original grantor. So for example, we have language such as to A, so long as A is in college. So long as connotes some sort of duration. So for this period of time, while A is in college, A gets to own this piece of property. We call this a fee simple determinable. As soon as A finishes college, their ownership interest is done. So once that happens, the property is going to revert back to the grantor. So the grantor has what we call a future interest. A, who owns it right now while they're in college, has a present interest. The next one, as I said, is similar. Fee simple subject to condition subsequent. Again, we have some sort of conditional language, but it's not durational language. It might be to A on the condition that A can't bring animals on the property. To A, but if A starts smoking cigarettes, O reserves a right of reentry. There's some sort of condition attached. And here, once that condition occurs, O, who's the grantor, we use O to refer to the owner or grantor of the property. O has the right to go onto the property and take it back from A. So unlike in a fee simple determinable, where the condition happens, such as A finishing college, and the property automatically goes back to O, in a fee simple subject to condition subsequent, when the condition happens, O has to go take it back. It doesn't happen automatically here. When they're creating a fee simple subject to condition subsequent, the grantor, that's usually O, has to include the magic words right of reentry or right of entry. They have to expressly reserve that right to go onto the property and take it back in the event that one of those conditions actually happens. The next one that we have is a fee simple subject to an executory interest. This one is, again, similar to fee simple determinable or fee simple subject to condition subsequent, in that there's some sort of condition or time attached to the grantee's ownership interest in the property. Here, the difference is that instead of going back to the grantor when the condition happens or the time expires, it's going to go off to a third party. So for example, we have to A, but if A smokes, then to B. So now that third party, B, is going to be the one taking the property. B has the future interest here, not the grantor. Finally, the last one that we have is a life estate. This is, for instance, where the grant says something such as to A for life. This one is fairly interesting. It feels more like a lease in the property. A gets to stay on the property for as long as they're alive. And then once A dies, in this example, it would go back to the grantor or the grantor's heirs if the grantor has also passed away. But A has what we call a life estate. And so life tenants, such as A, have to pay the tax on the property, they have to pay the interest on the mortgage, and they have to make reasonable repairs. They have to take care of the property and they have to leave it in good condition for the grantor, who's ultimately going to get it back once that person dies. But they don't have to pay things like the principal on the mortgage because they don't get a continuous future interest in the property. They have to give it back. So we're not going to make them pay for things that are ultimately investments in the property, really. So looking up to the other side of this handout, I briefly mentioned the future interests that could go along with the present interests. So on the left-hand side, we have present interests. On the right-hand side, we have future interests, and they're listed here for you. If the property is going to be going back to the grantor after the present interest expires, we call the grantor's future interest either a right of entry, a possibility of reverter, or a reversion, and it depends on which present interest you have. So for instance, if it is a fee simple subject to condition subsequent, we call the future interest a right of entry. If it's a fee simple determinable, we call the future interest a possibility of reverter. And if it's a life estate, we call the future interest a reversion. Now, we talked about those fee simple subject to executory interests where the property ownership goes off to a third party upon the happening of some event or the expiration of some period of time. And so when it goes off to a third party, the third party is the future interest holder. So that one is represented on this chart by those future interests held by the grantee. So we either call that future interest in the third party a remainder or an executory interest. It's a remainder if it follows a life estate, and if it follows anything other than a life estate, it's called an executory interest. Moving on to the next section, which is on real covenants and equitable servitudes. A covenant is a promise to either do or not do something with regard to the land. And it's important because it binds not only the parties to the promise, but all successor owners who also have an interest in that piece of property. This could be something like people who agree to put up a fence between their two pieces of property and maintain it. You're promising or covenanting that you will maintain and keep that fence up. I'm going to give you an example of what a real covenant would look like and why it's important. So let's say, for instance, that I own a large piece of property on the corner of a busy intersection. It's actually a double lot. I own both pieces side by side. At the very corner of the intersection, on my portion of the lot, I put a gas station. And I happen to be the only gas station at this intersection, so I have the monopoly here, and it's a very lucrative business for me. So I decide I'm going to sell off my other half of the property. I don't need it. I'm doing fine with the gas station. But when I sell it off, I don't want the purchaser to ever be able to put a gas station there. I don't want that competition. So I could theoretically enter into a contract with the purchaser where the purchaser agrees not to build a gas station. But here's the problem. If the purchaser, let's say I sell it to Bob, Bob turns around and he sells it to Charlie. Well, Bob and I have a contract where Bob agreed not to build a gas station, but Charlie wasn't a party to that contract. So Charlie, as soon as he buys it, could build a gas station. And that's not good for me. So not only do I want to bind Bob by this promise, I want to bind everyone in the future. I never want anyone to build a gas station on this property. So that's where real covenants come in. As long as the real covenant is properly created, not only is the immediate buyer bound by the covenant, but all future successors are also bound by that restriction as well. Now, there's two terms here that you'll see, real covenant and equitable servitude, and they both apply to that idea of making a promise or a covenant with regard to the land. The difference between them is the damage that the plaintiff is seeking. So let's say, for instance, I sell that piece of property to Bob. Bob turns around and sells it to Charlie. Let's assume for now that a real covenant was properly created that prohibited Bob and Charlie and everyone else from ever being able to build a gas station. Well, Charlie ignored the covenant and he built a gas station. If I wanted to recover money damages from Charlie, I would sue him under a theory of real covenants. If I wanted instead to get an injunction from the court, so I want the court to issue an order prohibiting Charlie from building or continuing to build this gas station, then I would sue him under a theory of equitable servitude. So either way, they're enforcing the same promise. It's just a difference of what damages do I want to recover? Do I want money or do I want to stop him from being able to build this gas station? Now, there are requirements that must be met for either one of these. For a real covenant, you have to show privity. Privity is a fancy word for relationship. So privity looks to the relationship between me and Bob, the grantor and the grantee, and also the relationship between Bob and Charlie to make sure that Charlie is in fact a successor in interest. So we look for privity. We look for intent to bind future successors. So I wanted to not only bind Bob, but I wanted everyone in the future to be bound by this promise. You look for notice. So when Charlie bought the property, did he know about this restriction? And you do this by putting it in the deed. When I deed the property to Bob, the deed should include the covenant that Bob can never build a gas station on that property, nor can any future successors build a gas station. And then finally, the promise has to be something that touches and concerns the land. In other words, this is something that makes the property either more valuable or less valuable. So if I had, for instance, sold the property to Bob and I said, and I never want you to bring animals onto the property because I'm highly allergic, that has nothing to do with the property. That's really specific to me personally. So that could not be the basis of a covenant. But this promise regarding the gas station, this is a proper basis for a covenant. It does touch and concern the land because Bob's inability to build a gas station here makes that piece of property probably less valuable to him, but it makes my property more valuable to me. If you notice on the bottom left-hand corner of this first page of the chart, there's a brief note about the rule against perpetuities. This is something that a lot of professors briefly mention. It's very confusing. There's pretty much a running joke in law school that this is one of the most complicated, confusing, difficult to understand topics that you may encounter in your first year of law school. So because of this, what I've seen is a lot of professors expect you to know that it exists and what it is, but they don't necessarily make you apply it to anything. Now, you could be in an anomaly of a class where the professor, like I said before, does choose to go in a different direction and cover something like this in a lot of depth. But I'm just going to briefly explain what it is and how it works and why we need it without going into a long explanation of how to actually apply it. So the rule against perpetuities, I'm going to start with why we have it, prevents someone from giving a piece of property with certain conditions attached that could bind or change the ownership interest of that property years and years and years and years down the line, long after that grantor is probably dead. We don't want people controlling the transferability of property from their grave. So that's where the rule against perpetuity steps in. So the rule against perpetuity says no interest in property is good unless it vests, if it does, no later than 21 years after a life in being at the creation of the interest. So for example, let's say a man has a piece of property that he gives to his children. He says, I'm giving you this property on the condition that you maintain a school on the premises. And if you don't maintain the school, then it's going to go off to my best friend's nephew. So we have the grant of property. And if you think back to the different types of freehold estates we talked about, this is probably a fee simple subject to condition subsequent. So he gives it to his children, A and B, on the condition that they maintain a school. And then if they don't maintain a school, it's going off to, let's say, C. So it's actually a fee simple subject to an executory interest, and C holds the executory interest. Now, here's what could happen. The person gives A and B the property. A and B maintain the property as a church. So no problem yet. Their kids inherit it. The kids maintain it, as a school. Their kids maintain it as a school. They leave it to their own children. Those children maintain it as a school. And then their next line of descendants, I think we're at great-great-grandchildren, maintain it as a school. And then their kids finally decide, you know what, we don't need this school anymore. We're going to tear it down. Now the condition happened. So now that triggers the property to be transferred over to C, or whoever the friends, nephews, children's children are at that time. So this could happen. You can imagine a scenario where this is happening, let's say 250 years after the original grant was given. So that original grantor, he is long dead, yet nonetheless, his condition is affecting the transferability of this piece of property years into the future. And we don't want that to happen. We don't want to attach those types of conditions to property. We want property to be as freely transferable as possible. So this rule against perpetuities simply says that the grant is not valid. We would basically give it to the children, A and B, without the condition that they have to keep it as a school. We just ignore that piece of it. The last part of this first page is on easements, licenses, and profits. I want to explain what an easement is. I'll give you an example. So let's say, for instance, I live in a neighborhood that is near a lake. I don't live on the lake. Let's say I live across the street from the lake. But the person who lives across the street from me, they have lakefront property. Well, I could get an easement over their property, which gives me a right to go onto their property and access the lake. That path that I have over their property would be considered an easement. So you'll see some vocab here for easements, such as easement appurtenant. And this refers to an easement that benefits property. So my house, my piece of property, is adjacent to that other piece of property that's lakefront. And so my property is actually benefited, not me personally, by that easement. And this is important because what's going to happen is if I sometime down the line decide to sell my piece of property, if it is in fact a properly created easement, when I sell my property, the purchaser gets not only my piece of property, but they'll also get the easement. So properly created easements are transferable and do in fact automatically transfer to the new purchaser. There are some ways to create that easement initially. So even before it's transferred, how do my neighbor and I go about creating this easement? An express easement is in writing, so we could have a written agreement where that person agrees to let me come onto their property to access the lake. Some of the other ones are a little bit more confusing and they don't necessarily apply to this fact pattern that I gave, but it could be something like an easement that's implied by prior use. So it's a strip of property that someone has been continuously using as an easement, and then they sell off a piece of that property, but they get to keep using that easement. It could be an easement implied by necessity. If someone is landlocked and doesn't have access to utilities or roads, they could have an implied easement over their neighbor's property, giving them the ability to get to the road. Or it could be an easement by prescription. We're going to talk about adverse possession at the end of this video, and you're going to see that adverse possession is very similar to an easement by prescription. So I'm going to talk about that at that time. Now, once the easement is created, like I said, until it's terminated, it transfers with the land. It binds not only the current property owners, but all future successors who have an interest in that property as well. So it could be terminated by one of these different methods listed here. And if it is properly terminated, now no one else has any access to or rights to that easement. This could happen if, for instance, there is merger. So the two pieces of property, the one benefited by the easement and the one burdened by it, merge. One person buys both of them. Now the easement disappears. You could have a release, that person across the street from me, and I might agree to give up the easement, so we put it in writing. You could have abandonment or estoppel, where the person decides to stop using the easement, and let's say the other person relies on it. So my neighbor says, okay, well, if you're not going to use this path anymore, I'm going to put a vegetable garden in here. So they know that I'm not going to use it, and they use it for some other purpose instead. Or it could be an end of the necessity. So that person who was landlocked and got an easement to be able to access the road, let's say that person becomes unlandlocked. They're no longer landlocked. They don't need that easement anymore. There's no more necessity. So the easement would disappear. Some additional vocab for you. A license is a little bit different from an easement. A license is permission to go on property, but it's not transferable. So if an easement is properly created, it can be transferred and it follows the ownership of the land. But if all you have is a license, so for instance, if my neighbor just told me, feel free to come across our property anytime you want to get to the lake, we didn't properly create an easement there. All we have is a license. So if I did sell my property, I couldn't sell that license along with it. It's not transferable. And finally, the last note we have is on profits. A profit is like an easement in that it gives someone the ability to go on the property, but you actually get a little bit more with a profit. Not only can you go on the property, but you can also take things off the property with you. This could apply in an instance where someone has an easement on property that is, let's say, rich in natural resources. So if I have a big piece of property covered in trees, I might give a profit to a lumber company to let them come onto my property and take the trees off. On the next page of the handout, I want to talk first on the right-hand side about concurrent estates, as we're still talking about freehold estates. When we talked about those freehold estates, so fee simple determinable, fee simple subject to condition subsequent, we're classifying what type of interest that person has presently. Concurrent estates contemplates a situation where two people or more own the property at the same time. So for instance, we looked at a scenario where the grant says to A, and A has a fee simple absolute. In a concurrent estate situation, the grant might say to A and B. Now we have two people, A and B, who are concurrent owners. So these types of concurrent estates look to the relationship between A and B. Freehold estates look at the relationship between the grantor, who's usually O, and the taker, which was A. So we're looking at a different type of relationship here. There's three types of concurrent estates. Those are joint tenancies, tenancies in common, and tenancies by the entirety. So we're first going to talk about a joint tenancy. A joint tenancy has to go through a lot of steps to make sure it's properly created. And the reason for this, if you look down at the bottom of the section on joint tenancies, is because of the right of survivorship. Two people who are joint tenants in owning a piece of property have a right of survivorship. So let's say, for instance, my brother and I own a piece of rental property together. If we own as joint tenants with that right of survivorship and one of us dies, so let's say I die, my brother automatically takes over my interest in that property. That means that I can't leave my interest in that property in a will. I can't sell it off by myself. There are certain things that apply to protect my brother, the other joint tenant in that instance. So because of this important interest that my brother holds, we want to be really, really certain that that's what the two parties intended. They intended for this right of survivorship to apply to this piece of property. So they have to go through some hoops to create it. They have to use the right language that should be given to A and B as joint tenants with rights of survivorship. And you have to have what we call the four unities. This is under the bullet point, the first bullet point, which says creation. And the mnemonic for the four unities is TTIP. That stands for time, title, interest, and possession, meaning that the joint tenants have to take the property at the same time. They take that property under the same title, so one deed grants to both of them. They share equal rights to possess the property, and then they have an equal interest in the property. So if you have two people, it's a 50-50 interest. If you have three people, it's a 33 and a third, 33 and a third, 33 and a third% interest. You have to have those unities to properly create a joint tenancy. A tenancy in common, which is the next type of concurrent interest, is the default interest. So if you don't want that right of survivorship, or if you don't properly create a joint tenancy, the parties default to a tenancy in common. And the big difference here is that in a tenancy in common, the interests of the two tenants is easily severed. So if here instead my brother and I owned that piece of property as tenants in common, then he could freely sell off or devise his interest in the property in his will. He could leave it to, let's say, his kids when he dies. I could sell off my interest in the property. I can leave it to my children and my will upon my death. You don't have that right of survivorship in a tenancy in common. The third one is a tenancy by the entirety. This one specifically applies to married individuals. So if my husband and I purchase a piece of property together, we would be tenants by the entirety. Excuse me. Like a joint tenancy, tenancy by the entirety also comes along with the right of survivorship. So if my husband died, I would automatically get his interest. If I died, he would automatically get my interest. It's just a little bit easier to create. You don't have to jump through as many hoops as the joint tenancy because we kind of presume that if two people are married, they'd most likely rather have that right of survivorship implied in their ownership. All right, I'm going to scroll back up. And the next topic, moving away from freehold estates, we're going to talk about non-freehold estates, or in other words, landlord-tenant issues. The first section we have here is on types of tenancies. This is actually something you may be somewhat familiar with. Most people have at some point in their life rented some sort of property. And so you can think about the lease that you signed and what type of lease it was. So it could be a tenancy for a fixed term. This is referred to as a tenancy for years. That name is misleading. Even though it says for years, it doesn't actually have to be for years. For instance, a tenancy from January 1st until June 30th, it's only 6 months, but it's still a tenancy for years. A periodic tenancy is where the lease simply repeats for a certain period of time over and over and over and over until proper notice is given to end that lease. So for instance, this would be something like a month-to-month lease. So you keep going with the lease. You rent it every month and it continues to the next month until you give proper notice to let the landlord know, or they let you know, that the lease isn't going to continue anymore after this point. A tenancy at will allows either the landlord or the tenant to terminate the lease at any moment's notice. They don't have to give advance notice at any time that they want. So no specified time period, no notice required. That would be a tenancy at will. And then finally, we have a tenancy at sufferance. This usually happens following a tenancy for years where the tenant stays after. So for instance, in that example where I'm leasing property from January 1st to June 30th, if I'm still in the property on, let's say, July 5th, I am a tenant at sufferance. And the landlord here has a few options. They could kick me out because I shouldn't be there anymore, or they could decide to impose a new tenancy on me. They could say, well, you're still here, so I guess you want to stay a tenant, so let's figure out what the new lease term is. Looking at the rights and duties of the landlord and the tenant's duties are pretty straightforward. The tenant has to pay the rent and not commit waste. Don't damage the property. The landlord, on the other hand, has a few more specific duties that they owe the tenants. They have to provide the tenant with quiet enjoyment. That means that they have to let the tenant possess the property without interferences. So for instance, if the heat doesn't work, the tenant can't really possess the property and enjoy the property if the heat doesn't work, if you're in a state where it gets really cold in the winter. That would be a breach of the covenant of quiet enjoyment. The landlord also owes a warranty of habitability. Very similar. They have to make sure that the premises are habitable for the tenant. And finally, the landlord cannot evict the tenant. And a lot of times where we see a gray area with eviction is what we refer to as constructive eviction, where there's some sort of condition on the property that causes the tenant to leave and in essence become constructively, not actually, they weren't forcibly removed, but constructively evicted from the property. So for instance, the heat not working. If I was renting an apartment where the heat stops working, and it's January in Michigan, so it's very cold outside, and I say, you know what, I can't live here anymore, so I pack my things up and I go stay with a friend, I can argue that I've been constructively evicted by failing to fix the heat or provide me with adequate heat. I can argue the landlord breached that covenant. Now, I could also argue that the landlord breached the covenant, the implied warranty of habitability, because you probably need heat in that situation to make the premises habitable. A lease can end by eviction if the landlord has grounds to evict. So if the tenant breaches one of their duties, such as that duty to pay rent, the landlord could evict the tenant. It could also happen by surrender. So if the tenant decides to leave early and the landlord accepts it, the landlord says, no problem, even though there's still time left on your lease, that's okay, I'm going to let you go. But if anyone is trying to recover damages for breach of lease, they always have a duty to mitigate those damages. So if, for instance, the tenant doesn't pay rent and is evicted, the landlord, if he wants to sue for unpaid rent, has to try to mitigate how much money he collects from the tenant by trying to release the premises, that apartment, to someone else. He should try to find someone else to start paying rent there so that his damages don't keep adding up and adding up and adding up. I told you we would come back to the topic of adverse possession. Adverse possession is a very unique concept. It's not something that we see all too often in everyday life. So this is kind of a fun thing to learn in law school. It's the idea of someone taking over someone else's property. And basically they're there for so long and they hold the property in such a manner that they become the true owner of the property. There are 6 things that you're looking for in order to determine if someone who takes over another person's piece of property becomes the true owner. So you have to see that they are holding the property continuously. It can't be enough. It's not enough that they just go there to this piece of property once, come back and never visit it again. Basically, let's say someone finds an abandoned parcel of property. They don't know who the owner is, but they decide to move on to it. They move on to that piece of property and they build a small cottage on the property. And they live on that property continuously. That would satisfy this first requirement. The next one is that they have to hold it hostilely. That means that the true owner of the property didn't give them permission. If you have permission from the true owner to be on that piece of property, then you're not adversely possessing it. But if you take that piece of property and you never get permission, you can show that hostility requirement. Third, the person has to be actually on the property. And furthermore, they get the piece of property that they're actually possessing. So even if the true owner, let's say, owns 100 acres, if the adverse possessor is only taking and using 1 acre, they only get 1 acre if they're able to show that they meet the requirements of adverse possession. Next, the possession has to be open and notorious, meaning that if the true owner came along, they would see the adverse possessor on that property. The adverse possessor cannot hide their possession. They will not be satisfying this requirement and cannot become the true owner of the property. Next, it has to go on for the statutory period. Under common law, this adverse possession takes 20 years. So that person who finds the abandoned property and builds the cottage on the property and is actually living in that cottage has to stay there for 20 years before they become the true owner of the property. And then lastly, their possession, the adverse possessor's possession, has to be exclusive, meaning that other people, the general public, is excluded from this piece of property. They're the only ones there. I'm going to skip down to the very bottom of the last page, the second page of the handout. Property transactions. This is something that professors may or may not cover in a real property class. My real property professor didn't cover it. And I think one of the common reasons it's not covered is because there's so much here is that it actually ends up being its own class. So this may be something that you touch on, if at all, but it's covered in a lot more depth, typically in some sort of elective class that you could take in your second or third year of law school. And this is true for this box labeled property transactions, and also the box to the right regarding mortgages and security devices. These two things go hand in hand and are often touched on in their own entire class. So I'm just going to briefly explain what this is referring to. So property transactions is talking about the process of, let's say, purchasing or acquiring a piece of property. So if I decide I want to buy a house, the various steps that I will go through in order to become the true owner of that house are listed here in this box. So first of all, I'm going to probably go to some sort of open house, or I'm going to get a realtor to show me this house that I'm interested in. I'm going to make an offer to the seller. And when the seller accepts my offer, we now have a contract. So there's a lot of overlap in this section between property and contract law. But the seller and I are now under a contract. There are certain requirements of the contract, certain things that have to be included in that contract. Additionally, the next step is that the seller has to give me marketable title. So they promise to get marketable title by the time of closing, meaning that they're going to give me, when they sell me this house, title that a reasonable person would accept. I don't want to buy a piece of property worried that someone else is going to come along at some point and kick me off of it because they have a better claim to this piece of property. Instead, I want marketable title. I want it reasonably clear of any defects. At the time the contract is signed, this is listed in step 3, certain things happen. Now, I don't become the true owner of the property when I sign that contract, but I do acquire an interest in the property. And the buyer's interest in the property is considered equitable title. I hold the equitable title to the property. The seller holds on to legal title until we actually close. And then step 4, the closing date. This is where I, the buyer, get the entire interest in the property. So this is not an overnight thing. It's not like you can look at a piece of property, say, I want that property, and be in the house the next day. This is a process of signing the contract at the beginning and then getting to the closing at the very end when the property actually transfers. Mortgages are the financial piece of this. So the purchaser may need to get a loan to be able to purchase this piece of property. I just want to touch on this vocab. A mortgage is the name of the security device that the purchaser gives the lender. So we often refer to the mortgage as the loan itself. So you might say you have to pay your mortgage this month. You're actually paying the loan. The mortgage is the security device that the bank holds on to that they can exercise or execute upon in the event you don't pay the loan to take over the piece of property. They can take the property from you via the mortgage if you don't pay the loan. So the mortgage is what we call the security device. The bottom box on the left regarding recording acts. Now it goes along with property transactions, but this is something that I've seen in my experience most real property professors cover, even if you don't cover property transactions in detail. And a recording act becomes an issue when there's a dispute over the ownership of property. Usually between 2 or more people who all think they have an interest in the same piece of property. So I'll give you an example. Let's say that I have a house in Michigan and I'm going to sell it. So I agree to sell it to a purchaser, Bob, who lives in Illinois. And when I sell it to Bob, he says, I've got some things to wrap up in Illinois still. I'll be in Michigan in a few months, and at that time I'll move into the property. I'll take it from you. So I've already sold it to Bob. Bob has already given me money for the house, but I know that Bob is in Illinois. So I decide to be sneaky, and I'm going to sell it to someone else. I'm going to sell it to Charlie. And I go to Charlie and I say, hey, Charlie, I have this house in Michigan. Do you want to buy it? And Charlie says, sure. So now Charlie pays me for the piece of property. Well, I'm going to take that money. I take Bob's money. I take Charlie's money, and I flee, and now no one can find me. So now Bob and Charlie both think that they own this piece of property, and they're left to fight it out amongst themselves. So the common law rule here that applies to who has the highest interest in the property is first in time, first in right. Whoever took first wins. So in my hypo, Bob would win because I give it to Bob first. But that's really unfair to Charlie. What was Charlie supposed to do? So a lot of jurisdictions, because of this unfair situation to Charlie, have enacted what we call recording acts, where they give some protection to someone like Charlie who couldn't have possibly known that I had already sold this property to Bob. So the different types of rules that jurisdictions have are notice acts, race notice acts, and race acts. Race acts are fairly uncommon. The types of rules that you typically talk about are notice acts and race notice acts. And basically, they look to see whether Charlie knew about Bob's interest. So did he have notice? And if it's a race notice statute, did Charlie record his interest in that property first? So in a race to record, did Charlie win the race? So if Charlie can meet those elements, he can show he did not have notice of Bob's interest. And if he has to, he can show that he recorded first. The recording act would actually let Charlie win. It overcomes that common law rule, and it would give the property to Charlie because that's what the rule deems more fair. If, on the other hand, Charlie can't show that he took without notice, or he can't show that he recorded first, then Bob by default would win under that common law rule. Very last piece of the real property handout is eminent domain. This is actually typically covered in a constitutional law class. It does regard real property though, so some real property classes might touch on it, but the right comes from the Constitution, so it's more common to see this come up in that class. Eminent domain is the idea that the government can take your property for public uses. But if they do so, if they take your property, they have to pay you just compensation. This commonly happens when, let's say, for instance, the government decides to put in a new expressway or freeway through a certain area. And right now, there are a lot of houses in that area. The government can use their eminent domain power here to demand that you sell the property to the government. And they have to pay you for it. They're not just taking it for you for nothing, but you don't have an option to say no. They can use this eminent domain power for that purpose. So I hope you found this helpful, this overview of real property law. As I said, you probably won't cover all of these topics in your real property class, but hopefully this gave you a brief overview of some of those topics that you do end up covering so that they make a little bit more sense.